Hello, my name is Tony Liu, and I'm the founder of Focus Law. We're helping business owners break free from dishonest partners and bad deals. Now, let me ask you something. If a business partner, let's say it's your business partner, got angry tomorrow, could they walk into the courtroom and take the control of your company before you even get a real trial? Because in a recent California case involving a successful restaurant business, that almost happened. This is a very closely held company with multiple owners, and some of them work inside the business every single day. Over time, the relationship broke down and accusations started flying. The issue about money, about management, and the fairness. Sounds familiar? One shareholder even made a bold move, and he sued and asked for the court to do three things: to freeze the business financially, to stop cash from being taken out, and appoint a court-controlled receiver to run the company. And yes, the trial court say yes. Can you believe that? Now, pause for a moment and think about what that really means and how that's going to affect you. A receiver can step in and control the key financial decisions and have access to the bank account, the payment, decide how the business is going to operate. In other words, the people who build the business can suddenly find themselves watching from the sideline. And even if the business survives, the financial cost, the emotional cost can be enormous. And here's what changed everything. The other owner appealed, and the higher court, the appellate court in this case, reversed the whole thing. Not because the appellate court decided who was right and who was wrong about the money. They decided because the legal foundation wasn't solid. Okay, what do I mean by that? Company itself had not been properly brought into the lawsuit in the first place. And the shareholder who filed the case couldn't even prove that he owned enough share of the company to demand such extreme remedy. In other words, the paperwork just did not match the power move. Now, what nugget can you take from this case? What can you learn from it? I think there are three. First, court control can happen fast. An ownership dispute, when it escalates, you may not have months to react. You may have only days. And once the court step in, your option can be limited and shrink really quickly. Second, the ownership must be clean, clear, and provable. Handshake deals and vague meaning notes won't protect you when the stakes are this high. If the ownership structure isn't documented properly, you may lose the leverage when you need the most. And third, procedure matters more than most owners realize. In a high-stake case, the side that follows the rule precisely often gains leverage clearly or early on. And the side that cuts corners, even unintentionally, can watch their case collapse. If any part of this feel familiar, the tension with the partner, the messy ownership records, money disputes, or threats of legal action, don't wait until the very last minute. Don't wait until the situation explodes, and that will be too late. Reach out for a quick conversation. The right strategy early on protects your business, your position, and your option. And if you know someone who is in the partnership that is starting to crack, forward this video. It could save them a very expensive lesson. Give us a call, 714-415-2007. We'd love to have this conversation with you and see what we can do for your business.